YouTube, it's Tone back with another one for you, and this one is the Foreclosure Defense Handbook. I want to say this is the third video, could be the fourth, though I'm not 100% sure on that. So, you guys are gonna like this one here. So let's get into it. So we're gonna talk about the issue of a defective instrument. So hang on, let me try to move this thing out the way. Okay, so if the promissory note is owned by thousands of parties, then there is no one party that may come forward to lay claim on the promissory note. If no one party can be named, the beneficiary or the lender, then the promissory note is defective. If no loan assignment was properly done, it cannot be fixed. A lender cannot simply reverse engineer the title of the deed of trust or promissory note to make it better. Once an instrument is defective, it cannot be used to collect the debt. If the term of the deed of trust mortgage can be shown to violate applicable state law, then it is too defective. If it is defective, then it cannot be used to give the lender the due on sale clause. The terms of the deed of trust must be respected in whole, and one cannot pick and choose which part to respect and which part to ignore. You have to understand how to read the terms of the deed of trust mortgage so you can articulate and defend the title against fraudulent claims. So I would recommend that you bring out the mortgage deed of trust from your closing packet and take a careful look at them to see if there is any of the above mentioned defects I mentioned. You might be surprised to see what you discover. And that's the thing too, man, is when you start looking at your agreement terms and the paperwork that you actually sign at the bank, you're gonna be fucking surprised to see how that all plays out and the things that you probably missed. So let's get into the Fair Debt Collections Practices Act. This is 15 USC. This is an awesome little code right here. It's to protect the consumers. It's consumer law. Okay. So as you recall, the pretender lender becomes a debt collector after 60 days delinquent. This is the only way they can negotiate a loan modification with you because it gets discharged out of the REMI. Now keep in mind that when it gets discharged, that means that the promissory note is no more and the debt is discharged, meaning that you don't owe them anything anymore. Okay, but they're not going to tell you that, but I will. So if I have included a copy of the FDCPA in the appendix at the end of the book, you can also simply Google Fair Debt Collections Practices Act. I talk about that shit a lot on my channel. Alright, so I even did a video on that too. You can check it out, 15 USC. So let's talk a little bit more about debt collectors. It is a scam. Debt collectors depend on people's ignorance to collect their ill-gotten gains. This is one of those dirty little secret bankers that have been hiding, one of the dirty little secrets that bankers have been hiding for years. They don't want you to know about this scam. We are blowing their dirty laundry out in the open because we are sick of seeing so many people suffer at the hands of bankers. And they are pretty fucking greedy. You know what I'm saying? And I mean, it is fucking disgusting how they kicking, like, you know, old elderly people out on there. I mean, it's kind of funny, but, you know, at the same time, it's fucking grimy. You know what I'm saying? So, but let me give you an example to illustrate the point. Let's say you are a farming supply shop owner, and I come to ask you for credit. We've known each other for years. You say, sure, I used your credit to buy some seeds and fertilizers for my farm. Sadly, we had a flash freeze this year and all my crops died. So I owe you $100, but I cannot pay you and go out of business. As a business owner, you can do one of the two things. You can carry the debt as an asset. 2, you can assign it to a third party through endorsement. 3, you can write it off as a loss. So that's it. So let's take a look at each of these cases. And that's what I do for my clients too. Whenever I discharge the debt, they essentially assign it over to me, and I move forward with the discharge process. So it just takes a different amount of times for different situations. That's all. So that's it. So let's look at each of these cases. If you carry the debt as an asset, then you do not get tax credits for the loss. My purchase of seeds still count as revenue for the purpose of taxes. If you assign it to a third party endorsement, then I will owe the money to the third party. The requirement is that I signed a promissory note and you physically endorsed the note to the other party. In this instance, the debt between you and I are settled. I now owe the third party. You cannot write off the loss as a tax write-off. And this is what they're doing a lot too. They're sitting here writing off the debt, getting the credits from the IRS, and they're offsetting the taxes that they would have paid for any of their income. And so they're getting the credits essentially dollar for dollar, and then they're going to turn around and charge you the full face value of whatever the note was, which it is no more. Okay, so uh, what is it? So if you write the debt off as a loss, then you do not then you not only do you not count my purchase as revenue, but the loss you suffered through the bad debt is offsetted against other income. And that's what I just said. In other words, that's what I just said. So they're basically writing off the debt. It's offsetting whatever they would have had to pay to the IRS uh, because they're using the debt to offset it. A debt collector is someone who is not the original creditor, buys an offsetted debt and attempts to collect on it. This is very important for you to understand. This is why the government created a set of laws called the Fair Debt Collections Practices Act, USC Title 15, 1692, in order to minimize the deceit and protect people. Sadly, not many lawyers even understand this mechanic. They think debt collectors are acting legitimately. And these motherfuckers are not. These motherfuckers are not acting legitimately. I mean, they're fucking legitimately believing that they can collect on it. But legally, no. Legally, they're not fucking able to. But they do it because everybody's ignorant to the facts here. So let's say once a debt has been written off, it is discharged. It cannot be collected again. Debt collectors use deception to convince people that they were assigned a debt. And I mean, I'm pretty sure a lot of you have gotten that, where they sold your loan off and you get a fucking piece of paper from somebody in the mail saying, oh, we're now the servicers of your loan. You no longer have to pay XYZ, XYZ, and now you owe us XYZ, right? And the fact that you don't send it back rejected means that you fucking accepted the offer because you hung on to it. That's just how this shit works. You know what I'm saying? So it's crazy, but that's how this works. It's administrative fucking scam artist is what it is. So how does this relate to a REMIC and a debt collector? As we discussed earlier, the individual shareholders are the real and beneficial interest holders. Since the individual shareholders cannot endorse and assign their portion of the loss, they then have to write it off as bad debt. The trustee of the REMIC cannot do either because the trustee is not the real and beneficial holder of the promissory note. The REMIC has given up that right when it chose to structure itself as a special purpose vehicle for the purpose of a straight tax pass-through. The only way your lender can foreclose on you is they rely on the same deception tactics used by debt collectors. The Fair Debt Collection Practices Act governs the deceptive practices also. Remember, a debt collector pulls off their deception through people's ignorance. This is what your lender is going to do to you. That is why in all their communications you will see this is an attempt to collect a debt. An original creditor is not required to disclose this. So if you are in court, or if you are counsel representing your client, it is important for you to ask the opposing counsel to stipulate the nature of their ownership of the note. Oftentimes, opposing counsel will come into the courtroom representing that their client has repurchased the note, not realizing that they have in fact brought fraud into the court. If your opposing counsel is ignorant, then they are not lying. It is up to you to get them to stipulate the true nature of the negotiable instrument through interrogatories and discovery, including subpoena of account records. If you do this, watch how quickly the blood drains from the opposing counsel's face. It is quite a sight. And that is kind of funny. So yeah, if you're ever in court, you definitely want to get the court to go ahead and subpoena all of the accounting records so we can do a forensic accounting on the accounting records, right? Because there's a lot of things that have to be proven there. Otherwise, these people are going to go in there just saying whatever the fuck they want. And if you don't call them out on it, then legally they can do it. So a defective instrument is not enforceable. An instrument that has been previously discharged and bought as bad debt is not enforceable. Don't be fooled. It is like buying a cheap knockoff Rolex watch in Mexico. It might look the same, but underneath the face, it's not real. So keep that in mind. And it's just strange how they've been doing this for so long. But I mean, they're making so much fucking money on this that I'm sure they got everybody fucking paid off. For real. So the debt validation letter. So this is something that I'm working on too, a validation packet for for the foreclosures, the mortgages, and shit like that as well. I'm actually in the middle of doing that. I'm almost done with them. So the debt validation letter. Let's analyze the Fair Debt Collection Practices Act, and specifically the portion governing validation of debt. Under USC Title 15, Section 1692G, you are entitled to ask a debt collectors for the verification of the debt. Upon dispute of the debt, all collection activities must cease until the debt collector can validate the debt. Sadly, the consumer only has 30 days to dispute the debt, or else they admit to the debt. If you have received a notice of default, NOD, from your lender, you will see that there is language specifically that says if you do not dispute this debt within 30 days, then you admit to owing this debt. Go on, grab your letter, and take a good look at it. And this is how they're fucking doing it, bro. They're sneaking fucking nonsense like that into into a letter. Something as stupid as that is gonna make it legally binding for them to go ahead and try to collect on you. It's crazy. But when we do our, administrative process, we also back them into our stipulations as well. Because once you start to hit them with the cease and desist, 15 USC, you'll see how they just stop sending you letters in general, and then you can just go ahead and back them into your judgment, so you can get summary judgment on them. So if you have not, where is it? If you have not received a notice of default letter, or if you have received it within 30 days, you can still send a notice of debt validation letter to your lender to dispute the debt. I have included a sample of the NOD dispute letter on, and so there's a little, there's a little link here too. If you guys want the book, definitely grab it. It's on page 46 of the book. When you grab it, there's a link here that'll bring you right to the sample letter that you can use. So, however, this does not mean you waive your rights to challenge the lender. If you are more than 30 days past default, you can still do it. You can write your lender and your trustee in a non-judicial state demanding that they produce proof of claim under FDCPA under USC Title 15, 1692G. Your lender is required to respond within 30 days. Failure to do so results in a violation of the FDCPA, which carries a penalty of up to $1,000 per violation. You simply have to sue them to collect. The FDCPA also has special damages provisions for class actions. 15 USC 1692K, recovery of statutory damages for the class is limited to 1% of the debt collector's net worth, or $500,000, whichever is less. So you see they already have damages in the amount stipulated here in the 15 USC. So you don't have to try to figure out how much you're going to charge them. It's already here. And all you got to do is prove their violations, sue them, and you fucking get that money, okay? So you will know when the debt collector doesn't have the note when a response sent back giving the borrowers either a "we don't recognize your request" or stating that the information is proprietary. Don't let them get away with that. The FDCPA rules are clear. In most cases, the lender servicer will send you anything but the items requested. Most of the time, debt collectors will send the following: some papers printed out from a computer, not sure what they are; nothing certified, notarized, and especially not dated recently; nothing showing their name and signature on the original lender or the past note holder; nothing proving the notification of a transfer; simple copies of some kind of billing statement, etc. And so that's the nonsense that they fucking engage in. And they're never going to put themselves in a position where they're going to incriminate themselves by giving you what it is that you asked for. They're just going to fucking pretend to not know what you're talking about, or they're going to silently acquiesce into your summary judgment. So all of which are unacceptable. The lender, servicers, and debt collectors absolutely know what the legal requirements are. They will challenge anyone who disputes a debt to see if you know the law. This is why this is important for you to know what the laws are as well. Under the Uniform Commercial Code, Section 3-204, the name and the signature of both the beneficiary and the original creditor must be disclosed in the same document. Clause 3-204D, the signature of the borrower must be included as well into the assignment of transfer, unless a clause in the deed of trust mortgage waives that. Most deeds of trust disclose this at clause number 20, and I have seen that too, where you sign it and it says that that the note may be transferred or sold or anything like that. And it doesn't matter if you fucking know it or not. The fact is that if they do sell it or fucking transfer it to somebody else, then nobody has the right to foreclose. It doesn't matter if you sign the fact that you know that it was gonna happen. All right. So FTC, HUD complaint, and controller of the currency. If you believe the mortgage servicer has not responded appropriately to a written inquiry, you should contact the state's Attorney General Consumer Protection Office. You should also contact the Department of Housing and Urban Development to file a complaint under the RESPA regulations. It is important that you issue complaints to these authorities because they cannot act on their own. They need a damaged party to give them the authority to prosecute a case. The more people complain to these authorities, the more likely they will take notice and investigate. In your complaint, explain to them that you have asked, provided copies of your communication, and where they broke the law, specifically under the Fair Debt Collections Practices Act 1692G. And this here is giving you the address to write to and all that. The Office of RESPA and Interstate Land Sales, Department of Housing and Urban Development, 451 7th Street, Southwest Room, 9154, Washington, D.C., zip code 20410. So you might also want to contact the Federal Trade Commission. FTC works for the consumer to prevent fraudulent, deceptive, and unfair business practices in the marketplace, and to provide information to help consumers spot, stop, and avoid them. The FTC's address is 600 Pennsylvania Ave Northwest, Washington, D.C. 20580. All right. So let me write this down, the time here for the slide. Okay. So you should also write to the Office of the Comptroller of Currency. This is the organization that oversees banking and banking practices. You can write to the Office of Comptroller of Currency at Comptroller of the Currency, Administrator of National Banks, Washington, D.C. 20219 would be the zip code. So what about my debt obligations? But I have been brought up to be honorable. I am a man of my word. I see the promissory note promising that I would pay. I got my house. I am now in default. The bank has the right to foreclose on my house. This is what they have us programmed to believe. Okay? So most of us are decent, honest folks. We believe in paying our debts. Millions and millions of people echo the above sentiment. You are not alone. I am not. And so like, this is why when we discharge the mortgages, it's funny because a lot of people just really think that they owe these motherfuckers money. So they think that they're going to get in trouble by discharging their loans, when in fact they don't owe these clowns anything. And that's the thing. So like, it's hard for people to understand this if they don't study. You know what I mean? But the more that you study and you start to see the fucking scam that they're fucking literally perpetrating on the whole world. It's not good guys, bad guys, middle guys. It's not any of them. They're fucking everybody. Everybody's getting fucked. And it's not just on mortgages. It's on fucking vehicles. It's on boats. It's on fucking whatever you finance. These motherfuckers are playing you. Okay? So, millions of us are decent, honest folks. We believe in paying our debts. Millions and millions of people echo the above statement. You are not alone. I'm not talking about a free lunch. I'm not talking about scamming the system, nor am I talking about advantage of some bizarre loophole in the law. What we are talking about is fairness, equity, and giving the everyday homeowner a fair shake. Heads I win, tails I win. This is the shit that they play. So the beauty with the capitalist system is that it encourages free enterprise. It encourages people to take risk, with high risk coming with high rewards. Oftentimes you win and sometimes you lose. However, in the situation where heads I win and keep all the money, tails I get bailed out, which is what the banks do, it gets down to a question of fairness and equity. Remember, the bailout comes from the taxpayers, your money. And that's crazy because you guys bail out the banks and then you still pay them a fucking mortgage. You already paid them when you bailed them out. What the fuck are you paying them for? So they received over $3.5 trillion of free money, pretty much with no strings attached, to do as they see fit. On the other side of the spectrum, millions of homeowners are being kicked out of their homes. No loan modifications to compensate for being upside down. And if they owe more than their house is worth, that's being upside down. So where's the fairness in that? Particularly when they can use the same bailout money to pay their top executive millions in bonuses for the numbers of homes they can foreclose on and how quickly they can process them. I don't know about you, but this sort of behavior is enough for the pitchforks to come out. Enough is enough. And really, I mean, how much are you guys gonna take? You guys just keep taking it on the chin. Really? Get this book, study this shit. This is really gonna help you get a good understanding of how this shit all works. Alright? It is a game of chess. Stop playing checkers with these clowns. That's what I got for you for now. until we meet again.